Hi, my name is Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to discuss the case United States v. Richardson. This case was heard in the Supreme Court of the United States in the year 1974. Let's go ahead and jump into the facts of the case. So Richardson, the plaintiff, is arguing that the CIA, the Central Intelligence Agency, needs to output basically a document that says what they spend all of their public funds on. He says that the Constitution, it's pretty clear the Constitution does require that if any money is drawn from the United States Treasury, then that needs to be reported to the public from time to time as far as what that money is spent upon. And because the CIA uses public money, Richardson is arguing that he needs to know what the CIA spends money on. As a taxpayer, he should know what the CIA spends their money on. Now, the court doesn't really reach the merits of that claim. The court, rather, is mostly concerned with the standing of the plaintiff here, Richardson. Standing, as we know, the constitutional requirements are injury, causation, and redressability. Now, there's two other prudential requirements that the court has kind of imposed on itself. One, it says you can't bring claims for a third party. And then the one that the court is most specifically interested here in this case is that you can't bring a generalized grievance that is common to all taxpayers. The court talks about how that was first laid out in the case Fotheringham v. Mellon, where a taxpayer tried to sue the government. They said that, a taxpayer has a grievance that's common to everyone. And one taxpayer can't bring a claim on all the other taxpayers. You need to have a specific injury to have standing before the court. Now, later in the case Flast v. Cohen, the court did actually carve out an exception there. It said that if Congress uses its taxing and spending power to promote one religion over another, then a taxpayer might have standing in that case. So if Congress violates the Establishment Clause of the First Amendment, then a taxpayer might have standing to bring a claim. So that's the one exception that the judiciary has recognized to this prudential principle of you can't bring a generalized grievance. So the court ultimately does dismiss Richardson's claim. It says, you don't have standing. This is just a generalized grievance that's common to the public. You as a taxpayer don't have a specific enough interest. There's not a nexus between your tax payment and the CIA expenditures that warrant you the opportunity to have standing before this court as a plaintiff against the United States government. So they say, sorry, there might be merit to your claim, but you don't have standing to bring it. And the court ultimately says, it's the role of Congress to determine these things, and Congress is elected by the people. And for that reason, if Congress wants to say that, the CIA doesn't have to provide a line-by-line expense sheet of all the things that they spend their public money on, and Congress has the discretion to do so. But a taxpayer does not have standing to bring that claim against the United States government. There's an interesting dissent where they talk about how, maybe this guy should have standing. And mostly there's this clause in the Constitution, which we read in Article 1, where it just says no money shall be drawn from the Treasury unless there actually is a public accounting of what those funds are used for. And the dissent kind of uses that constitutional question to show that, we should probably expand the rule of Flast v. Cohen and allow taxpayers to challenge other types of things. Now, the downside of the dissent would be if you do allow a taxpayer to challenge something like this, you're going to open up the floodgates of litigation. And the courts do ultimately become more of a policy-making arm if you allow taxpayers to bring all types of claims towards the court, even though they don't have a specific interest, if it's just a generalized grievance. And so that is the reason for this prudential principle against generalized grievances. You won't have standing if it's just you're a taxpayer with no specific interest. Now, I just want to jump into, maybe a hypothetical where maybe the court ought to consider expanding the exception. Right now, they've only recognized that exception in the Establishment Clause. So if Congress uses money to, favor one religion over another, then you will have standing as a taxpayer. But maybe we should extend that to another portion of the First Amendment. And to display that, I want to give you a brief hypothetical. So let's envision a world where the United States government creates its own social media platform, right? Maybe there's concerns across the populace that one social media platform is more liberal, another is more conservative. And maybe we need to have a government social media platform be the arbiter for discussion so we can ensure there's free speech. Now, let's say there's a Congress controlled by conservatives, and this Congress controlled by conservatives starts censoring people that are more liberal, right? It censors these people that are more liberal. And if that social media basically arm of the government started censoring people, that are more liberal, now would just a general taxpayer who funds this social media company have standing? Would just someone who doesn't post and doesn't get censored have standing, saying that, Congress has actually enacted a law that prohibits free speech. It alters and hinders free speech. Now, does a taxpayer have standing to raise that? And I think on this United States versus Richardson holding, it would be hard to argue that they do. Now, it might be a more interesting scenario if one taxpayer was trying to post on this government-owned social media and they were censored. And then maybe that individual suffers an actual injury and they would have standing to bring the claim. But do we now require someone to post something controversial on a social media page in order to have standing for a lawsuit? Or should we just allow everyone to bring that claim so they don't have to damage their reputation by posting on that social media platform? So there might be reason to think it would be good to expand this exception of the First Amendment, where the court has said you can bring a claim as a taxpayer if it's against the Establishment Clause. Well, maybe we should also consider free speech. Now, that could be a slippery slope and open up the floodgates of litigation, but just something to think about. It is a nice idea that the taxpayer would have the power to sue the government. The problem is, pragmatically, it's just difficult for the courts to handle all those lawsuits. And then also it makes the courts more of a policy-making arm rather than Congress, as the founders probably had more envisioned that role for the government. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.